Section 184 of this new law, it provides for medical examination of the victim that has to be conducted with her consent as such within 24 hours of receiving information about the commission of the offence. We know very well that any investigation, any examination, if it is conducted belatedly, very late, then it loses its very purpose. And for all you know, the result may be not helpful to the prosecution at all, and the accused may get away with the worst of offences. And we know on technical grounds, many accused have got away. So such provisions will bring about, real justice to the citizens as such. And medical report also would have to be forwarded within 7 days under 184 of this new law. So a time frame. As I go along, I'll be saying a number of things about time frames, timelines, time limits being in place. That is really a new incorporation coming about through this new law. Just as you had this Arbitration Act amended and many timelines are in place, and it has become really helpful. Earlier we would say arbitration is really inexpensive, and it is a quick procedure compared to the regular court proceeding, which are not really so. But timelines being in place, that is really becoming a real alternate dispute resolution. So also with timelines coming in place in this new law, it will be really helpful to everyone. Justice would be done, I would say. If you go further, the citizens are also empowered to engage their own legal representation to assist the prosecution under Section 18(8) of this new law, New Criminal Procedure Code, Bharatiya Nagrik Suraksha Sanhita. Earlier also, were they allowed to represent? They were allowed to represent. But one had to really, say, I am the victim's advocate, this, that. And he may not be, as a matter of right, though there were case laws in support of that. But today he can say, okay, this section, the law itself, the statute itself gives me this right, to say what I have to on behalf of the victim. Therefore, victim could be represented to assist the prosecution. Look at the terminology. Prosecution is doing its job because that particular offense would be grave, cognizable, and therefore he needs to do a good job of it. But over and above that, he gets the assistance of a victim's advocate also in support of what he's doing. And it would be really helpful to bring justice. And with all such provision, the criminal justice system is made all the more transparent, accountable, accessible. These are not just words or just adjectives, but they are really incorporated in a big way in this new laws as such. You'll find in Section 230 of this new law, Bharatiya Nagrik Suraksha Sanhita, that the supply of documents to the citizen has been introduced. And that is also really helpful. Citizen is kept in the loop because he is the one who needs to know. Then you have, as I said, victim has a right to free medical treatment and victim compensation under Section 396. Of course, somewhat provisions regarding compensation, they were always there in 357 and the subsequent sections. But then this has been categorically brought about in this new law as such. So free medical treatment and victim compensation, it is kind of empowering or rather giving a right, entitlement to the victim. Also, you have provision for, as I said, witness protection scheme that will embolden the witness to come forward. Today, as I said earlier, which I commented, victim is a bit hesitant, witness is a bit hesitant to come forward for various reasons. And to a great extent, those fears would go away and he would perhaps want to volunteer and come forward and help the justice delivery system. When I was giving a talk to some cops and some law students about a week or so ago, I found that one of the cops came up and requested the student fraternity and the lawyers who were present and the others, some NGOs were present. I found them requesting all these people to help the police. Especially by coming forward as witnesses. It was really a request from them to do so because they found that perhaps they could be handicapped if the citizens don't cooperate to bring justice to citizens themselves. So there was a request which went from them. Now this new laws, they have thereby brought about Nyaya-centric approach to criminal justice. Nyaya is justice-centric approach. The whole approach has changed as such. Like if you go to higher studies, you'll find that the whole shift is happening from punishment to kind of reformation and all that. No? So that shift is really happening in a big way. It's introduced in this new laws, and it will be seen more and more as time passes by. And also you will see the last section perhaps of section this new law, Bharatiya Nagrik Suraksha Sanhita, section 530. It allows for investigation, inquiry and trial proceedings also to be held electronically. My God, what a world of difference it would make. Imagine the hassle that one has to take, or the trouble that one has to take to get to the place where he has to depose, and so many other things it would entail. No? All that trouble could be saved with this introduction of this electronic investigation, inquiry and trial as such. Going further, this, if you talk about this key changes, as I said, in Indian Penal Code, the number of sections are reduced 511 to 358. They have added 20 new offences. Compulsorily, some minimum punishment is laid down there. So once the guilt is proved beyond reasonable doubt, that is a requirement of criminal law. Whenever a guilt has to be established, it has to be established beyond any shadow of doubt, beyond reasonable doubt. Unlike your civil proceedings, where there is that terminology or phrase called preponderance of probability. Even if it was probable, that could be acceptable in civil law, but not in criminal law. Either you're guilty or you're not. So that is how the criminal law goes. There are two new laws which have come about, which we have pointed out. One is Bharatiya Nyaya Sanhita 2023. The other is Bharatiya Nagrik Suraksha Sanhita 2023. These are criminal laws. The third one is law pertaining to evidence. That is Bharatiya Sakshya Adhiniyam. Evidence law is applicable to both civil as well as criminal law. It won't be right on a part to say 3 new criminal laws are come. No. 2 new criminal laws are come and 1 evidence law. There are changes made in that evidence law. So 2 new criminal laws and 1 evidence law. So imposing minimum punishments for certain offences, thereby it makes it difficult for certain accused to get away. Minimum that mandatory punishment he would have to undergo once the offence is established, when the wrong that he has committed against the society is established as such. And we'll also find as we go along, I will mention those offences for which community service is prescribed. When you come to that, you'll find that there is no clear mention of what duration that community service should be. Whether it should be 6 months, 1 year, 2 years, nothing of the sort is mentioned. It seems that the legislatures have left it to the discretion of the judge, the magistrate, to impose the duration of that punishment of community service. First of all, it won't be right for me to say that it's a punishment. It's a service towards the civilized society, and it should be looked at it in that manner. It's to reform a person as such. Therefore, we will not use the wrong terminology and say punishment. We would rather say though it is under the punishment category, but its basic intention is to reform a person. And then the quantum of certain punishments have also been enhanced. Earlier it was this much, now it is enhanced to double the fine amount, and punishment also is increased. Somewhere death is brought about, somewhere till the person, till he lives, as long as he lives. That kind of, exactly not that terminology, but that is what the legislators mean. I will clarify that thing also, what is imprisonment for life and what is that thing where the punishment would be till as long as he is alive. I'll clarify that as I go along. Okay, when I come to specifics. Then another key feature could be it has consolidated crime against women and children. That was necessitated because this is a category which needs special treatment, and if all laws pertaining to them, they are brought under one roof, chapter 5 as I said, it would be really helpful. As we go along, we'll tend to memorize also, and we'll know where to look for offences against such category of people. Then when it comes to false promises and all that, as I pointed out earlier, stricter punishment is imposed. Section 69 will tell us so. Then death penalty for gang rape is also introduced, death penalty. Okay, section 70. And I said mercy petition and all that, they are to be disposed of timely. That also has come about. Then as we go further, you'll see that in CRPC there were 484 sections earlier. Now those number of sections are increased to 531. don't get a little put off because the number of sections are increased, or even when they are reduced also. That does not really matter. What matters is whether the changes are good or bad, whether they are helpful to the citizens or not, looking at it from the citizen perspective. I would rather say it would perhaps not be right for anyone to look at something only from a certain perspective. You've got to look at something, holistically, from the citizen point of view, from the accused point of view, from the society point of view, from the judiciary point of view, from the judge's point of view, and all stakeholders' point of view as well, witnesses as well. So it should be that way, I feel. Then, we would also see that in this new criminal law, you would see they have replaced some 177 sections. They have added 9 new sections. They have repealed 14 sections. Why am I throwing this number? Because some would say that there are only cosmetic changes made. Kali naam badal diya aur kuch kiya nahi. That is not true, I feel. I was reeling under a similar impression much before I could delve deep into some of these laws and try to understand them better. The presumption in law is that whatever the legislature made, that is good, and we have to find the purpose behind it and the intention of the legislature behind it. Only when we have that presumption in mind, we would go about in a right way, and we would be able to appreciate what has been done. Would there be some problem with the new laws which have come about? There may be, but that for the judiciary to interpret the laws, and the laws when they are tested as such, if at all by anyone. Now, we have seen that there is an enhancement of the use of technology in investigation. Also, there are increases in fine. Also, FIR processes, victim protection, that has been streamlined. We have spoken about zero FIR, e-FIR. This is e-generation that we are talking about. No? So there is e-FIR also. There is that 176. The law permits audio, video recording. Audio, video, not just video, audio as well, of victim statement. It makes a huge difference. No, because many times, if you are a practicing lawyer, you would know the person in the box is saying one thing, then he said, no, I have not said this. Then he would say, I don't know why the police have not covered what I've said. All these disparities and discrepancies and inconsistencies, or going back on one statement or sticking to one statement and not finding that statement in the thing that is recorded. All those, to a great extent, all this would be addressed with the coming of this, introduction of this audio, video recording of victim statement and so on. I had one case where the lady had lodged an FIR, and thereafter she had given a statement. Thereafter she gave yet another statement, and thereafter yet another statement. And then finally she started saying, the first statement which I gave was incorrect, the second one was correct, then she said the third one was correct, and there was a whole lot of confusion. Her argument was, or justification was, I don't know Marathi very properly, and therefore what I said in the first statement wasn't even made wasn't even told to me properly, and I didn't really understand what I had signed, and all such things she was saying. Perhaps all these things would be put to rest to a great extent with this incorporation of this latest technological advancement in the provisions of law itself.